I guess it's good afternoon, technically, at least here in the UK. I would like to welcome everybody to this special webinar that's a collaboration of Outer Temple Chambers and Oxford University Deep Tech Dispute Resolution Lab. My name is Mimi Zhou. I'm the co-founder of the lab at Oxford, and it's my great pleasure today to chair this no doubt will be very exciting webinar on different dimensions of crypto assets. So sort of background to this is obviously there is a lot of buzz around crypto assets over the last few years, particularly last year as the UK Jurisdiction Task Force of the Law Tech Delivery Panel delivered a statement chaired by Sir Geoffrey Voss on the status of crypto assets and smart contracts. And that statement essentially articulated that crypto assets, including but not restricted to virtual currencies, can be treated in principle as property, and also smart contracts are able to satisfy the requirements of English law and therefore enforceable by the courts. So what's important, I think, that came out of that statement is the need to understand the legal status of the asset class that you're trying to regulate before we try and figure out whether there is a point in introducing any type of regulation. So there's a lot of debate on this particular area, and as such, we organized this webinar to delve more deeply, particularly in terms of the technical aspects of crypto assets in the context of more generally, but also in the context of, for example, white-collar crimes. So we've got a really fantastic panel today of speakers from Oxford Deep Tech Lab and also Outer Chamber Chambers. It's a wonderful collaboration between these two organizations. Here at Oxford, our lab is based at the law faculty, but we've got basically researchers from 12 different departments of the university, and our mission is to create an international hub of multi-stakeholder and multidisciplinary research collaboration, basically to bring together researchers, policymakers, practitioners from around the world that's interested in the role of deep technologies in the area of dispute resolution. So our research equips stakeholders, such as legal practitioners, with evidence-based toolkits to navigate the challenges and opportunities in the uptake of deep technologies, including AI and smart contracts in our area of dispute resolution, and come up with practical and creative solutions for stakeholders to address pain points in this current system. So we're very pleased to be working with Outer Temple Chambers, which is the first set of chambers that we're engaging with to deliver this webinar. We've also provided webinars to their actual in-person seminars, actually before COVID, to their clients and members of chambers in the areas of artificial intelligence in the law and also smart contracts. So today we turn to our third collaboration, which is on crypto assets. And without further ado, I would like to introduce members of this panel and run through with you the structure of today's webinar. So first of all, we have John McKendrick, QC. John is a very experienced advocate, an advisor with 20 years of litigation experience in the UK and internationally. He's appeared before the Supreme Court and the Privy Council, and has also practiced in the Caribbean, where he was Attorney General of Anguilla. He's a fluent Spanish speaker and has long-standing connections with clients in Latin America. He was appointed to Silk at the age of 39, which was last year. So Chloë Bell is a member of Chambers, and she joined in 2017 She's developing a busy practice with particular focus on commercial and public law. Chloë was previously a judicial assistant to Lord Mance, who was the deputy president at the Supreme Court. She also spent 2 years working at the Court of Justice at the European Union in Luxembourg. We also have my colleague at Oxford, Hing Liu. He is a non-stipendiary lecturer at Oxford and doing his doctorate on the legal nature of digital assets. Hin is also currently a legal advisor to Fusang, a company based in Hong Kong, and he advises this company on legal and regulatory issues in relation to the listing of digital securities and digital asset custody. And last but not least, we have Jeremy Scott-Joynt, a member of Chambers. He focuses on business crime and regulation and has assisted clients in dealing with the FCA, where he was seconded, the Serious Fraud Office, Gambling Commission, and other organizations. So as you can see, this is a very illustrious panel, lots of experts there coming from different angles. We'll first have Chloë and Hin run through the fundamental legal foundations of crypto assets. The second part then will turn to John and Hin to discuss the regulation of virtual assets and also discuss a bit about virtual asset providers. And finally, we will turn to Jeremy and Hin to discuss crypto assets and smart contracts, particularly in the context of white-collar crime. So without further ado, I'm going to turn over to Chloë and Hin.
Good afternoon. Thank you for joining us. Hin and I are going to look at the fundamental legal foundations of crypto assets. And as Mimi referred to the UK Jurisdiction Task Force legal statement, it makes sense to look first at the overarching framework in which crypto assets sit, before turning to issues of regulation, which obviously stem from that framework. And John and Jeremy are going to discuss that. So the biggest question on the legal community's lips is whether crypto assets are property and whether our existing property doctrines can apply to crypto assets. There have been a number of decisions in the common law world on whether crypto assets are property, and I've listed them on the next slide. And there's also been a number of decisions in other civil jurisdictions listed on the slide following that. But in view of the time, Hin and I are going to focus on the two most detailed final decisions to date, namely B2C2 and Coin and Rusco and Cryptopia. In fact, all of the other decisions listed on the previous slide followed interim applications and are therefore shorter and less detailed judgments. So I'm going to look at B2C2 and Coin. So the facts are relatively complicated, but I'm going to try my best to strip them back to the basics. The case was concerned a Singaporean cryptocurrency exchange operated by Coin. And due to various software and programming oversights, namely the failure to update passwords giving market information on prices for the exchange platform, certain trades were concluded between B2C2 and margin traders who had been trading using Ether, which had been borrowed from Coin against security of Bitcoin held by those traders in accounts with Coin. The erroneous trades were executed automatically by algorithms. Now, there was nothing wrong with the algorithms themselves, but as a result of the market data being blocked out because of the passwords not being updated, B2C2 sold Ether at about 250 times its appropriate price. And once a human being at B2C2 saw what trades had been executed, they said major Coin database breakdown. That was part of the evidence in the case. As a result, Coin reversed the trades, and B2C2 commenced proceedings in Singapore courts against Coin, contending that it should not have reversed the trades, and it brought causes of action in contract and for breach of trust. At trial, both claims were upheld by International Judge Thorley, who's a judge from the UK. And today I'm going to focus on the property question as addressed by the court. To succeed in its claim for breach of trust, B2C2 had to first establish that a trust over the cryptocurrencies had been created. And as I'm sure you're all familiar, to create a trust, it's necessary to demonstrate that the three certainties have been satisfied: certainty of intention, certainty of subject matter, and certainty of objects. On the issue of certainty of subject matter, it was necessary for B2C2 to establish whether cryptocurrencies are property which can be held on trust. And for the purposes of the trial, Coin was prepared to assume that cryptocurrencies could be property. Addressing this in his judgment, the judge confirmed that this was the correct approach. He said cryptocurrencies are not legal tender in the sense of being a regulated currency issued by a government, but do have the fundamental characteristics of intangible property as being an identifiable thing of value. The court was satisfied that cryptocurrencies met all of the requirements of the classic definition of property set down by the House of Lords in National Provincial Bank in Ainsworth, that they were definable, identifiable by third parties, capable of assumption by third parties, and having some degree of permanence or stability. The judge did not go on, as you can see on the next slide, to determine what the exact nature of cryptocurrencies was. That is, whether they were a shows in action, a shows in possession, or something else. And if we go over to the next slide, at paragraph 142, he made that comment and said that there was some academic debate as to their precise nature. The judge also held that the other certainties were fulfilled and held that Coin did hold the ether on trust for B2C2. This decision was then appealed to the Court of Appeal of Singapore, which delivered a 108-page judgment. I do pause briefly on the composition of that Court of Appeal because I think it's internationally significant. There were a number of Singaporean justices, including Chief Justice Menon. There was also a former Chief Justice of Australia, Robert French, and Lord Mance was sitting also as an international judge in that case. Coin did belatedly decide to dispute the proprietary status of cryptocurrencies on appeal. However, in a twist of fate, and thus depriving us of a detailed judgment from such an esteemed bench, the court unanimously concluded that it wasn't necessary to come to a final view on that question, because they concluded that even if cryptocurrencies could be property and therefore capable of being subject to a trust, the certainty of intention element was not satisfied in the case. The appeal court concluded that mere segregation of Coin's assets, which it questioned as a matter of fact, mere segregation was not sufficient. And Hin's going to look at that in a bit more detail in a little while. Nonetheless, despite saying that it did not need to delve into the property question, the court did do a neat survey of various decisions around the common law world on the issue of cryptocurrency as property. And it's quite a neat survey and is likely to be the approach taken by courts in this jurisdiction, i.e. looking across other jurisdictions to see how it's being dealt with. So that's quite useful from that perspective. But the majority did acknowledge that the precise classification of crypto assets would raise difficult questions. And this is what I briefly want to stop and take a look at, because we've not yet got that far in the case law. Once it's settled that crypto assets are property, the next stage of the analysis is drilling into what that means. And I think that is where the real difficulties will lie. So on the next slide, I've set out the orthodox classifications of property. And contrary to what the judge at first instance said in Coin, I don't think this is just an academic or taxonomical inquiry. Indeed, there are many practical consequences that flow from the precise classification of property, such as what causes of action are available, such as conversion or bailment, or what property defences might be available, such as exceptions to the nemo dat rule in transfer of title. I think the first issue that will need to be grappled with is whether crypto assets are to be classified as shows in possession, shows in action, or something else, a third category, something new. Many are quick to cast aside conceptualizing crypto assets as shows in possession because traditional notions of possession entail physical possession. And indeed, that does appear to be the view of the UK Jurisdiction Task Force, which you can see at paragraph 67 of its legal statements. However, others, including the Financial Markets Law Committee, consider that perhaps these traditional notions of possession are outdated. And indeed, the FMLC considers that legal certainty is likely to be greater if crypto assets are acknowledged to share the essential characteristics of shows in possession. And I tend to agree. But to convince a court of this, it's going to be necessary to demonstrate what counts as possession of a virtual asset. In other words, what amounts to the requisite level of control. For example, having the private key or demonstrating that you hold virtual coins in your digital wallet. If this is right, then bailment and conversion could be possible causes of action. And then comes the question of whether crypto assets should be treated as money. And related policy questions are, should certainty of trade trump title in the same way as for money? The FMLC appears to endorse the possibility of classifying at least some crypto assets as money. And the consequence of that will be that the nemo dat property claims, the nemo dat exception that applies to money will apply to crypto assets, and that a person who obtains them in good faith will obtain title to those assets. To address these questions, there's a real need to understand the fundamentals of these assets. And so that's why we at Azure Temple think collaboration with individuals at the Oxford Deep Tech Lab can assist lawyers in providing the right answers to those questions. I'm now going to hand over to Hyn, who's going to discuss the more recent New Zealand decision in Cryptopia.
Thanks, Chloe. So the second case, and this is the most recent case on crypto assets, is the Cryptopia case. So let us turn to the facts of Roscoe and Moore and Cryptopia. So in short, investors deposited bitcoins with a cryptocurrency exchange called Cryptopia, which went insolvent. And so naturally, the investors wanted to claim their bitcoins deposited at the exchange. On the other hand, other unsecured creditors argued that the relationship between the exchange and the investors was purely contractual, such that they could have their share pari passu with all the other creditors. And so that the investors, as well as the unsecured creditors, could only prove their claim, their debts in the liquidation, and claim pari passu with the other unsecured creditors. So there were over 800,000 Bitcoin investors with positive balances with Cryptopia, but there were also 37 creditors and 90 shareholders. So the case involved a classic priority dispute between investors and other creditors and shareholders. This priority dispute is just in relation to a different type of asset as opposed to, say, a physical chattel or a debt. So on the next slide, we see the main question dealt with by the court, which is, what was the relationship between the cryptocurrency exchange and the investors holding bitcoins with it? And the answer to this question would determine the entitlements of the investors. If the cryptocurrencies were held on trust for the investor, then the investor would be able to claim in priority to the creditors, either unsecured or secured. And the same would be the case if full legal beneficial title just resided with the investor. But if there's an outright title transfer to the exchange, then the exchange would have full rights of ownership in relation to the asset. And so any obligations undertaken by the exchange would be contractual. The upshot of this is that any rights held by the investors would be contractual, meaning that the investors' claims would have to rank pari passu with all the other unsecured creditors. And this is the key point. The investor wants to claim the asset back and doesn't want its rights to be diminished by other unsecured creditors. And this is why the characterization of the relationship between the investor and the exchange is so crucial. So what was held in that case? We see that the Bitcoins were held to be on trust for the investors. And this meant that the investors were able to claim the asset in priority to Cryptopia's creditors. And there are many fascinating aspects to this judgment, especially the question of whether cryptocurrencies can constitute property, but that can take up a whole day of discussion. So in the interest of time, I want to focus on certain trust-specific issues, specifically two issues. First, the certainty of intention to create a trust, and second, the outer boundaries of the trust concept and when exactly it shades into an outright title transfer. And I'll assume throughout this discussion that crypto assets can constitute property. So if we turn to the first issue, certainty of intention, as we know under English law, the creation of a trust requires certainty of intention, subject matter, and object. And I'd like to focus on the certainty of intention requirement because the certainty of subject matter and objects requirements are relatively uncontroversial. In relation to subject matter, we know that the property being held on trust is the cryptocurrency itself. Under English law, it's clear that a trust can exist over a fluctuating fund of assets, as we can see from Pearson and Lehman Brothers. And in relation to the certainty of objects, we know that the Bitcoins are held on trust for the investors, so there's no uncertainty as to who is the beneficiary. The certainty of intention requirement is much more interesting. What must be intended, at least as a starting point under the general law, is for the intermediary not to have free use of the asset. And how do we know this? This is to be ascertained primarily from the terms of the agreement between the investor and the intermediary, so the contract between the two. One important indicator of such an intention is that the asset is segregated from the intermediary's general assets, as this tends to indicate that the segregated assets are not to be at the free disposal of the intermediary. But as we saw from Chloë, this is not conclusive. This is just a piece of evidence from which the inference tends to be drawn that the intermediary is not to have free use of the asset. It's not a necessary connection. Another very important indicator of such an intention is whether the asset is held on the intermediary's balance sheet. If the crypto asset is being held on trust for the investor, it wouldn't be held on the intermediary's balance sheet. In contrast, if there was an outright title transfer, we would expect the asset to show up on the intermediary's balance sheet. And we see this in the judgment in Cryptopia itself. A crucial factor pointing in favor of a trust was that the intermediary, and I quote, did not assert any ownership in the cryptocurrency in its internal financial accounts. And what does this show? This shows that the intermediary didn't treat the assets as their own. And therefore, this shows that it's the free use element which governs whether, at least initially, there is the certainty of intention to create a trust. So if we then move on to the second issue on the next slide, about the outer boundaries of the trust concept. When is an arrangement no longer a trust, and when does it shade into an outright title transfer? We see this in cryptocurrency exchanges. Many cryptocurrency exchanges may want to exclude liability as much as they can, and also engage in securities lending to make further profits, and yet still claim that there is a trust, i.e. they want to have their cake and also eat it. Would there still be a trust, or does it become so much like a title transfer because in effect the exchange has something akin to free use of the asset? So what if we change the facts of Cryptopia slightly? Let's say that the agreement contained an extensive exclusion of liability, as well as a clause conferring a right of use on the exchange in relation to the crypto assets held with it, so it can trade the asset freely with any counterparty. What would the analysis be? So let's go back to first principles. For a trust relationship, this trust relationship imposes a default set of obligations on the trustee. The trustee is obliged to use the asset for the best interests of the beneficiary, meaning that it can't put itself into a position of conflict of interest or use the asset to make a personal profit. Also, if the trust is a bare trust, as was the case indeed in Cryptopia, the trustee is obliged to act on the beneficiary's instructions. But these duties can be heavily modified, and we see this in the Citibank versus NBIA case, where the issue involved contractual exclusions of liability. So in Citibank, a trust was upheld in seemingly extraordinary circumstances. The trust deed had considerable exclusions of duties that cut through what is traditionally thought of the irreducible core of trusteeship. So for example, the trustee was bound by the instructions of a third party, and also when instructed by the third party, the trustee simply didn't have to have regard to the interests of the beneficiaries when acting. And you may think this effectively nullifies the duty to act in good faith in the beneficiary's interests. And you might think this is such a core duty that it can't possibly be excluded without negating the existence of the trust altogether. But despite all this, the court still held that a trust existed. So we see the flexibility of the trust concept in relation to its outer boundaries. We also see this in the context of rights as well as duties. So apart from excluding duties, the agreement can augment the rights of a trustee such that he can behave more like an absolute owner. And we see here that as long as his rights aren't too much like those of an absolute owner, he can still be a trustee. So in Pearson and Lehman, it was held that even a right of use given to a trustee could be consistent with the existence of a trust. But there is a limit. If too many duties are excluded, or if too many rights are given to the trustee, the arrangement might not end up being a trust at all. There would instead be a title transfer. For example, the right of use becomes inconsistent with a trust, where the profits derived from the use of the asset are to belong exclusively to the trustee, as opposed to being shared between the trustee and the beneficiary. So in this situation, there would be a title transfer. Finally, if we recall the case of Street and Mountford, a case dealing with the distinction between leases and licenses in the land law context, Lord Templeman famously remarked that if you call a fork a spade, the law would still deem it to be a fork. So the law looks at the substance of the arrangement created by the parties, not the mere label attached to it. So if the label is inconsistent with the substance of the agreement created by the parties, then the law gives effect to the substance and not the form. If you call a fork a spade, the court will still hold it to be a spade. So in this case, in the trust context, the spade would be the trust and the fork would be the title transfer. And the court would recharacterize the trust as a title transfer, just as it would hypothetically recharacterize the spade as a fork. But if you create an object that behaves somewhat like a spade and somewhat like a fork, and you call it a fork, the court may marginally accept it as a fork, just like a court might marginally accept something as a trust, even if the trustee has a right of use. And this shows the outer boundaries of the characterization exercise, as well as the outer boundaries of the trust concept. And this is the end of our presentation.
Thanks very much, Chloe and Hin. So I'm going to call on John and Hin again for our second part. So we're moving now on to the regulation side of virtual assets. So over to you, John.
Thank you very much. Good afternoon, ladies and gentlemen. Your head is probably spinning somewhat from that clear exposition of legal and intellectual gymnastics to understand the nature of virtual crypto assets in the context of property and trust law, which presents one of the great challenges, obviously, for regulators. And as you will, I imagine, all know, some of the key principles of regulation are to protect consumers, protect the integrity of the regulated financial services market, keep an eye on competition, and be wary of potential criminal offences, and in particular, money laundering and terrorist financing. How does one do that when there remains a significant and extensive debate about the legal nature of virtual or crypto assets? And how does one do that when our traditional approach to financial services regulation remains based on nation-state models when we know that crypto assets are globalized or internationalized? And that provides many challenges for national regulators. We, in our very short 15-minute presentation, are looking at the FATF standards, particular standard 15, and we will highlight some of the different regulatory approaches different nation states have used. But undoubtedly, it remains a very significant challenge. As most of you will know, the Financial Action Task Force is now 31 years old, created in the late 1980s to deal with the avalanche of money laundering that really came out of criminal proceeds of crime and drug running in particular. The standards have been changed over the years, but to a relatively limited extent. And what you can see on the screen is the recent amendment to Standard 15. Standard 15, you'll probably all recall, dealt with novel forms of technology, but additional language was added to deal with virtual assets and virtual asset providers. And this is in force, and most countries are in the fourth round of their mutual evaluation process. So many jurisdictions are having right now to deal with how to implement this standard. And in fact, Hin and I are now working with the World Bank to draft laws for an Asian country and how they will set out regulation of virtual asset and virtual asset providers. Some countries are opting for wider legislation, some narrower, but all must comply in the fourth round mutual evaluation process with Standard 15. And before we get into a little bit more detail about what this standard requires, I'm going to hand over to Hin, who will take you through the next slide, which has some interesting definitions.
Thanks, John. So there are certain definitions in FATF which seem to befuddle most people. I mean, it seems to have befuddled me before I looked into this. And one of the main definitions of contained in the FATF is the definition of a virtual asset. And the FATF defines this as a digital representation of value that can be digitally traded or transferred and can be used for payment or investment purposes. Now, it's important to note that virtual assets don't include digital representations of fiat currencies, securities, or other financial assets that are already covered elsewhere in the FATF recommendations. So one example of this would be a fiat currency represented digitally in a bank balance, because that's a digital representation of an asset, but that's not included within the definition of a virtual asset. And now, before we proceed with our analysis of virtual crypto assets, I think it's also crucial to draw a fundamental distinction between native crypto assets and exogenous crypto assets. So native crypto assets are crypto assets that exist solely within the blockchain, whereas exogenous crypto assets are blockchain assets that are linked to an external asset outside the blockchain. So, for example, a simple debt security issued on a blockchain would be exogenous. And this is because the entry on the blockchain that you see refers to something outside the blockchain, i.e. the debt, or in other words, the obligation on the issuer to pay according to the terms in the relevant contract. And this obligation exists outside the blockchain. So conversely, a Bitcoin would be a native blockchain asset because the entry on the blockchain displays the location of the Bitcoin in question, and that's it. There's no external asset denoted by the entry on the blockchain, such as a debt or a physical chattel, and everything exists within the blockchain itself. So it's in this sense that a Bitcoin is a native blockchain asset. So what is a virtual service provider then? It means any natural or legal person who's not covered elsewhere under the recommendations and as a business conducts one or more of the following 5 activities or operations for or on behalf of another person. An exchange between virtual assets and fiat currencies, an exchange between one or more forms of virtual assets, a transfer of virtual assets, safekeeping and administration of virtual assets or instruments enabling control over virtual assets. And lastly, participation in and provision of financial services related to an issuer's offer and or sale of a virtual asset.
Thank you, Hin. Jeremy, could we move on to the next slide? Thank you. So the key documentation for anyone who's interested in FATF's international approach to ensuring national regulatory systems meet the standard is to look at obviously the recommendation 15 and its amendment, And bear in mind that that applies within the context of the 39 other recommendations, but also have a very detailed look at the interpretive note to recommendation 15. All of the standards in FATF have interpretive notes which are said to be the official view that the national regulatory systems must meet. And whatever the court's view it might be on the nature of virtual assets or virtual currencies, the FATF recommendations in point 1 make clear that regulators should consider virtual assets as property or proceeds or funds. The requirements for asset providers to be licensed or registered or set out, but the interpretive note makes clear that you needn't have a wholly separate financial services system to do that. And indeed, all jurisdictions that we've looked at have amended or adapted their existing systems. But the regulation may not be by a self-regulatory body. It must take place under a competent authority. And the regulatory threshold for the virtual asset transactions is above 1,000 US. In addition to the interpretive notes, you also have a very significant piece of guidance which runs to some 60 pages, which was published by the Financial Action Task Force in June of last year, and sets out very detailed provisions which all nation states are now working towards. Next slide, please, Jeremy. So what are the different national regulatory approaches to comply with FATF recommendation 15 seen within context? Well, that rather depends on what the jurisdictions are trying to achieve. Some of the smaller jurisdictions, which is why this slide begins with Gibraltar and Anguilla, have seen virtual assets as a potential lucrative new product and to sell from small offshore jurisdictions. Some see it as a basis to attract investment and are very keen for those involved in virtual assets to utilize their wider legal, accountancy and banking services in as much as they're relevant. Other jurisdictions are somewhat warier and have possibly less enthusiastically embraced the regulation, not necessarily seeing the regulation of virtual assets as a priority within their jurisdiction. But nonetheless, they must comply with the minimum FATF requirements on money laundering and terrorist financing. So the first jurisdiction we shall look at very, very briefly is Gibraltar. And Gibraltar has produced the Financial Services Distributed Ledger Technology Providers Regulations 2017. I think this is probably the most interesting regulatory approach that has been adopted in a number of jurisdictions. The legislation falls within the main Financial Services Investment and Fiduciary Services Act, but it has a bespoke provision to deal with those who wish to engage in distributed ledger technology, which, as many of you will know, encompasses a broad range of virtual or crypto assets. So anyone who is involved in that activity must apply for a license from the Gibraltar Financial Services Commission. Now, cleverly, I think, Gibraltar hasn't sought to be too prescriptive about the regulatory requirements for any provider of services based in or reliant on DLT. Schedule 2 to the regulations sets out regulatory principles which the DLT service providers must comply with. And they will be familiar to anyone who's been involved in financial services regulation. They include, for example, that the DLT provider must conduct its business with honesty and integrity. It must pay due regard to the interests and need of all its customers, and it must communicate them in a fair, clear, and not misleading way. It must maintain adequate financial and non-financial resources. It must manage and control its business effectively and carry it out with due skill, care, and diligence. It must have effective arrangements in place for customer asset and protection. It must have effective corporate governance arrangements. It must ensure systems and security access protocols are maintained. It must prevent and detect and disclose financial crime risks. And it must be resilient and have contingency arrangements for the orderly and solvent winding down of its business. Now, that is very much a flexible approach to good prudential regulatory standards, but it doesn't tell you very much about any individual DLT provider. Much will depend on essentially bespoke risk assessment by the regulatory authorities to those engaging in DLT. But clearly, it has been effective for Gibraltar, who have seen quite a significant uptake of virtual asset providers investing in the jurisdiction. And the catch of regulating the distributed ledger technology, I think, has been helpful in ensuring a wide range of virtual crypto assets are covered. If we move to the next slide, we'll see another jurisdictions approach, which is that of Anguilla, which is also a offshore jurisdiction. It's also a British overseas territory like Gibraltar. And in 2018, Anguilla passed the Anguilla Utility Token Offering Act. This takes a narrower approach to the Gibraltar legislation and seeks to regulate only utility tokens. And again, the idea behind the legislation was to attract investment into Anguilla and to provide a regulatory platform for commercial bodies interested in offering utility tokens to be regulated. Utility tokens were defined in the Act as neither directly or indirectly providing the holder, individually or collectively, with contractual or legal rights to ownership or equity interest in the pool of assets provided by the issuer, or to an entitlement to share of profits or losses. The idea really was to share in a venture, in a scheme. And in fact, I think the people who were behind pushing this legislation in Anguilla were in fact seeking investment for computer games. And there was, I'm told, tens of millions of pounds of investment behind the development and investment in computer games. So utility tokens was a bespoke aspect to be regulated by the regulatory authorities in Anguilla, and the legislation didn't seek to go beyond that. The regulatory scheme required the utility token issuer to produce a white paper, much like a prospectus, and the white paper set out the nature of the utility token offering, the risks associated, the timescale for the investment, and the likely benefits and risks. And the utility token offer would have to be approved and regulated and report to the Financial Services Commission on its white paper and its progress. Detailed regulations were issued under the Act. So that is, if you like, a specific piece of legislation to regulate an aspect of virtual assets in the hope of seeking investment. The third jurisdiction we look at very briefly is the United Kingdom, which hasn't really produced any legislation similar to Gibraltar or to Anguilla. And what isn't mentioned on this slide, I'm sure many of you will know that the Money Laundering and Terrorist Financing Amendment Regulations 2019 made a requirement from January of this year for crypto asset providers to comply with the AML-CFT regime. But the overall approach adopted by the UK has really been through softer measures, which you can see set out here, creating digital strategies, providing for sandboxes, and for providing a significant amount of guidance. The regulations on AML and CFT require certain types of crypto asset providers to comply with the AML-CFT standards, but not all of them. And I recommend a very interesting read to all of you. The FCA has published guidance on the regulatory perimeters of what are regulated and non-regulated virtual or crypto assets, is the favorite term in the UK. And very much that line is, I think, sometimes very hard to follow, very hard to work out what is regulated and what is unregulated and the rationale behind that. But there is a less, certainly a less holistic approach to regulation than, for example, adopted by Gibraltar, and certainly less detailed and specific in comparison with Anguilla for that particular type of utility token. And the fourth jurisdiction that we look at is Hong Kong, and I'll hand over to him to do that. Thank you.
Thanks, John. So Hong Kong hasn't introduced any legislation that specifically targets virtual assets. The main governing regime is that relating to securities, and that's governed under the Securities and Futures Commission. So the SFC, the Securities and Futures Commission, has regulatory jurisdiction over securities, which is defined under the Securities and Futures Ordinance, the SFO. If a platform falls within the SFC's regulatory ambit, it would have to be licensed by the SFC before it can offer securities, and also it would have to comply with the listing conditions imposed by the SFC, such as monthly reports, safe custody of assets, due diligence, etc. So does the definition of securities under the SFO encompass virtual assets? Now, the definition of securities is contained in Schedule 1 of the SFO, but it doesn't explicitly cover virtual assets. And there's no case authority covering whether the definition of securities under the SFO encompasses virtual assets. But the SFC's position paper on the regulation of virtual asset trading platforms, which was published last year, proceeds on the assumption that virtual assets constitute securities for the purpose of the SFO if the asset functions as a security, i.e. if it were in a non-virtual form, it would be a security. And the CEO of the SFC describes the Hong Kong regulatory regime as an opt-in regime. But as we've just seen, a virtual asset is a security if it functions as a security, in which case the SFC regime would be mandatory, not opt-in. So in what sense is the regulatory regime opt-in? So the sense in which the SFC's regulatory regime is opt-in as far as virtual assets are concerned is that the virtual asset provider can choose not to trade virtual assets that are securities. In other words, it can decide to exclusively trade virtual assets that are not securities, for example, cryptocurrencies. In this case, the SFC's regulatory regime would not come into play. An advantage of this approach, which is noted in the SFC's position paper on the regulation of virtual asset trading platforms, is that it enables one to tell whether a virtual asset exchange is regulated or not. If it offers virtual securities, you know it's regulated, and investors would be more protected. If it doesn't offer virtual securities, it's not regulated, and investors would know to take extra precautions when transacting on the platform or deciding to put its asset onto the platform in the first place. On the next slide, we see some key duties of a virtual asset provider under the SFC's regulatory ambit. And these include client asset custody, prevention of market manipulation, due diligence, anti-money laundering, know your client, and counter-financing of terrorism. In the interest of time, I'll focus on the first two, specifically client asset custody and the prevention of market manipulation. So firstly, client asset custody. The platform operator is obliged to hold client assets on trust, and this is to safeguard investors' entitlements in the event of the insolvency of the virtual asset provider. And this prevents the outright title transfer situation from happening. If you remember to my first presentation with Chloë, this is where the investor transfers full legal and beneficial title to the virtual asset over to the platform or custodian. Where this happens, the investor wouldn't be protected in the event of the platform's insolvency. And this is because all the investors would have no property rights in the asset, and all they have is a contractual claim against the platform, which means that they only have a pari passu entitlement alongside all the other unsecured creditors of the platform provider, and this would be disastrous for investors. Secondly, prevention of market manipulation. As we know, market manipulation is one of the main activities that have to be prevented from the very outset. People will find ways to manipulate the market, irrespective of the medium in which the assets are being held, i.e. through a virtual asset platform operator or through a traditional intermediary such as a bank. And we'll be exploring this with Jeremy's presentation, which is next. And some of these methods of market manipulation don't require a high degree of sophistication, such as the classic pump and dump scam. So if left unchecked, we would expect this behavior to occur, and we need virtual asset platform operators to provide robust safeguards against market manipulation. As such, there is an obligation on a platform operator to establish and implement written policies and controls for the proper surveillance of its trading platform to prevent market manipulation, including identifying and detecting anomalies, which would involve performing periodic independent reviews of suspicious price spikes. Also, this includes monitoring and preventing potential uses of abusive trading strategies and taking immediate steps to restrict or suspend trading when manipulative or abusive activities are discovered, such as by freezing accounts. And this is an overview of the main parts of the Hong Kong regulatory regime, and I'll hand over back to John.
And I'll hand straight back to Jeremy. Thank you.
Jeremy.
Sorry, Jeremy.
Thanks to everybody. Sorry, I've been on mute the last bit, both for good order and because this happens to be the time of the day when the garbage lorry goes past. I didn't think any of you needed to be hearing that in the background. I realise that we are running quite short on our time now, so I'm going to make this a really swift canter. Not through statements or suggestions, but really concentrating on the questions that get thrown up by the nature of these assets and the nature of these technologies from a white-collar perspective. And by white-collar here, I'm not just talking about fraud, corruption, money laundering. I'm also thinking from a civil fraud perspective, because there's some really interesting stuff, particularly one judgment late last year, early this year, which is a judgment called AA and Persons Unknown, which is possibly the least specific title for a case that you could possibly imagine, which dealt with the business of securing or freezing crypto assets. But as I said, Hin and I will try and make this one fairly brief, and we can follow up later. So the first thing really to say here is to talk from a financial crime perspective about the two critical errors that we think emerge when you're dealing with these technologies and these assets. And they're mirrors of each other. On the one hand, you've got the people who panic and say, I don't get this. I don't understand. The world has changed. The world is now different. Everything is different, and we must change everything in order to cope with it. The other people, and these usually the old guard, the ones who run financial crime in large institutions who, some of them, a few of them may be ex-cops, some of them not, who tend towards the view that there's nothing new under the sun, that every form of criminality is basically fraud is fraud, corruption is corruption, bribery is bribery, money laundering is money laundering, and so the technologies or the methods really don't matter. They're both wrong, because the critical point, in my view, and in Hin's as well, is really to think about the fact that yes, a fraud is still a fraud, but throughout history, the techniques and technologies have changed. And bluntly, the crooks are usually the first people to find interesting ways of exploiting new technology, even if they're still essentially stealing from somebody. Hin, when we were talking before, you were talking about the means ends categorization of this. That's a useful way of looking at it.
Yeah. So we can look at this in terms of means and ends, and I think that's quite a useful way to distinguish between the different schools of thoughts and situating them within the context of this debate. But as we know, people can and will perpetrate fraud, deceive people, and act maliciously. That's just human nature. We expect this in this world. And this has been the case no matter how advanced or primitive a particular society is. So the ends are the same. Sorry for being cynical, but this is our world. But what's changed is the medium over which these malicious and fraudulent acts can take place. So instead of them taking place in a physical shop or through face-to-face dealings, we can now do these things over the blockchain, such as through the classic 51% attack. So the means is different, but the ends are the same. So some people are mistaken in thinking that just because the end hasn't changed and it's fundamentally, just people acting maliciously, nothing has changed. When in fact the truth is that something has changed, specifically the means by which the particular ends can be achieved. And others are also mistaken in thinking that just because the means has changed, everything has changed. Well, the truth is that human nature hasn't fundamentally changed. The ends are the same. People will act maliciously, and they're just using more advanced ways of doing the same thing. And I'll hand back over to Jeremy to talk about.
Yeah, and essentially then, I mean, that's a really critical point. People remain people, and people will continue to look for opportunities, whether they're, in a sense, all financial crime is arbitrage. And when one approaches it from that perspective, it becomes a much more straightforward business of working out which is the means, which is the ends, and therefore what toolbox you need to approach it with and what set of skills. So the critical aspect when it comes to controlling or mitigating the effects of crypto-driven financial crime is to make sure you have both toolboxes on hand and both sets of skills on hand. I will say, therefore, that it's not necessary to have them both in the same body. With the exception of people in the deep tech, like, it's quite rare. So don't be afraid to stick a number of bodies on the problem and to make sure that you encourage the cross-fertilization between, for instance, compliance and legal disciplines and the technical disciplines. The middle line here is an interesting one. The uncanny valley, I think, is an important concept here, because part of the arbitrage that comes with exploiting this kind of technology for criminal ends is dealing with the fact that we're sitting in this uncomfortable middle area. The uncanny valley is a term that's usually used in robotics. It's the idea that people can cope with machines that don't look or act at all like human beings. They can probably cope with ones that pretty much are a slap bang analog to human beings because they can't tell the difference. But it's really weird dealing with something that sort of looks like a human being and sort of acts like a human being, and nobody knows how to deal with that. That's the uncanny valley. And in this case, we're dealing with the same. Technologies like the ones we're dealing with are no longer so new that they're utterly baffling and nobody wants to touch them with a barge pole. Neither are they sufficiently familiar that habits have been inculcated, whether that's personal habits of human beings or institutional habits of organizations, to be able naturally to deal with these. So we're sitting in this uncomfortable middle ground where sometimes people feel that it's familiar enough to deal with, but actually are going to get caught out. So in dealing with these things, this is back to the classic rule of financial crime, which is always think like the bad guy. The chances are if someone like me or John or Hin or Chloe or any of you guys can come up with a heinous and malicious way of utilizing one of these technologies, someone else who's actually going to do it has already thought of that, because let's face it, the purest incentive-driven market economy in the world is the world of white-collar crime. We are now just about out of time, so I'm going to move quite quickly through this. And I'm sorry, Hin, I'm jumping over one or two little bits here. There are core questions I think we need to deal with, and I will run through these quite quickly. Hin and Chloe in particular were talking about the property question. And the case that Hin was talking about, Roscoe, is particularly thought-provoking, I think, in this respect. Because obviously, if you are looking to secure assets, prevent them from being stolen, prevent them from being manipulated or abused, then knowing what they are and knowing what your obligations towards them and their holders are is absolutely critical. So both Roscoe, I would firmly recommend the reading of both Roscoe and Coin in terms of what they say. That's the first instance, Coin in particular, in terms of what they say about the nature of property and the ways in which, for instance, trust obligations can emerge, because they're dealt with quite differently because of different circumstances in those two cases. I'm not going to waste time now talking about that in detail, but I would urge you to look at it and think from that perspective about whether your whether your client's terms and conditions, whether their activities, whether their systems and processes may inadvertently generate obligations that they do not intend to have over the assets that they're handling, or indeed put them in a position where they may be the target of freezing or other proprietary techniques in order to reclaim those assets when they've been nicked in the first place. Hin, before this we were talking about, particularly in your case, transfer of title in the context of what these things are and how one ought to be thinking about it so as to avoid thinking about the wrong things. Now, could you elaborate on that a little bit?
Yeah, sure. So for any asset, for any piece of personal property, there are rules which determine when title transfers from A to B. So for example, in the case of a physical chattel, for example, my iPhone here, I can transfer title to this through a sale or through a deed or through delivery, say to Jeremy, with the intention of parting with title to this iPhone. And the same debate plays out in any sort of property. So for a debt, we've got rules on assignment. And in the blockchain context, we've also got rules on the transfer of title. We have to formulate a set of rules for the transfer of title. And many people talk about when exactly title should be deemed to have been transferred in the context of blockchain. People talk about whether it should be 6 or 8 or 10 confirmations. And they have a long debate about this. But I think what's more fundamental is to have a clear set of rules in the first place, to provide legal certainty, to guide behavior in the financial markets. And as long as we have a sufficient level of security on the blockchain, the precise number of confirmations matters less than the fact that there is a number that everyone knows and is guided by, no matter whether it's 6 or 8 or 10. We have to know whether it's 6 or 8 or 10, and that guides the behavior of the parties. We can't waste too much time arguing in detail about what the rules are. We just have to look at the bigger picture and recognize the importance of legal certainty. And this point is true even in the case of bank transfers, because it's important to have CHAPS rules that are clear to people so that people will know when money exactly is transferred. And it matters less whether an international bank transfer happens in 2 days or 1.9 days or 1.8 days. People can just adjust their behavior, and we're just doing the same thing in relation to blockchain transfers. So I think it's important to know to note that the existence of rules is more important, I think, than the precise details of whether it's 6 or 8 or 10 confirmations, as long as we know that there is a set of secure rules in place.
Indeed. And because we're short on time, I'm going to move quite quickly through the next couple of slides. And I'm really just going to point to materials that are worth looking at here. There is some really interesting research that came out not long ago where a bunch of people have managed to get into the Telegram and, the Discord and I think it was Signal rather than Telegram, actually, now I think about it, but certainly the Discord servers that are used by people running pump and dump scams on initial coin offerings. Now, this is your classic new tech, old crime issue. Pump and dump is probably the simplest, oldest, and most blatant form of securities fraud that anyone can imagine. That and its mirror version, whose name I frankly prefer, for those of you who are aware of it, which is short and distort. I love that. Now, for those who don't know, I'm sure most of you do, pump and dump is where you run up the price of a security, usually by advertising or convincing mugs to buy it, so that you can sell out on the peak. Short and distort, of course, is the other way, where you spread terrible news about it, or you convince people to sell so that you can buy on dip. Now, these researchers, and by the way, we will ensure that links to the various documents and cases we've looked at today get sent out to everyone afterwards. I'll be compiling that later. This research found some really interesting things about the absolutely blatant use of these communications channels to run pump and dump scams on initial coin offerings, exploiting both the security of these communications channels and the irreversibility and the exact timing that one can bring to trading into these coin offerings. So the secure messaging, by far the most lucrative forms of these scams, were utterly blatant, where groups of people were using the secure messages to set target times for trading in order to make sure the price rose at precisely the right time. And this was all happening in incredibly short periods of time, far shorter periods of time than you would expect to find in old-fashioned open market securities fraud. There's also a sense in which, in some cases, there was exploitation of the nature of the community that has grown up around certain parts of the crypto market. It's quite close, it's quite tight, it can be a little defensive, sometimes perhaps a little prone to conspiracy theories, a tendency to see themselves as ahead of the game and that anybody else who's criticizing them is automatically going to be wrong. Some of the scammers exploited that, as well as simply recruiting people in the community to assist them with the scams. I will send out a link. The research is fascinating, both for the old techniques and how they're applied to the new technology. I'm very briefly going to mention crypto hacks as well. We've seen these over and over again, whether it was actually Cryptopia itself in the Rusco case that Him was talking about, or a couple of years ago when Mt. Gox collapsed in Japan. It's an apocryphal story, unfortunately. It's not actually true, of a gentleman called Willie Sutton, who used to be a bank robber in the States, who was asked why he robbed banks, and he told the people who arrested him that that was where the money was. Well, clearly in this case, the point is that if you have the technical ability, and if, of course, an exchange has a vulnerability that you can exploit, the ability to hollow out that exchange and empty out its proceeds is probably going to be more lucrative more quickly than many other forms of potential theft of assets. The nature of the exchange, the nature of the technology, and of course the vulnerabilities that can come with especially wallet storage, are going to make it something that people are going to keep trying to get into, whether it was Gox, whether it was Cryptopia, or all of the rest. Moving on from there, because we really are short on time now, and I realise that, this isn't all doom and gloom. The nature of this tech does lead to some rather interesting possibilities when it comes to excuse me, when it comes to whether it's regulation or the management of financial crime. One, of course, is, and this isn't strictly to do with crypto assets, it's more to do with the underlying distributed ledger technologies. So many people, of course, are looking into this as a way of providing additional authentication, whether it's of identity from a CDD perspective in anti-money laundering world, or of other matters. We're going to see more and more of this, of the use of the technology to underpin other forms of transaction in order to secure them better. Now, that will bring its own vulnerabilities, of course, but nonetheless, it's a space that I think we should all be watching. Another point is, whenever people start getting scared about crypto assets, they always start worrying about the anonymity. But anonymity doesn't necessarily mean what we think it does it?
No, and people frequently do talk past each other when discussing whether the blockchain is truly anonymous. They mean different things when they use the term anonymity, and this just causes confusion. This is because there are two meanings of anonymity. The first meaning is that the identity of the parties is wholly obscured. There's no way to find out through the blockchain itself who the relevant parties are. So if in such a case, we eventually discover the identity of the parties, we would know that all the information leading up to that discovery was found completely outside the blockchain, because the blockchain doesn't tell us anything. So this is the first meaning of anonymity, in that the blockchain tells us nothing at all. The second meaning is that the identity of the parties is not revealed by the blockchain itself. So the blockchain can have pieces of code, but it doesn't say Hin owns 10 BTC. So the difference between this meaning and the first meaning is that the blockchain can be used as one piece of the puzzle to eventually find out the identity of the parties, because the blockchain does provide information. So if we know certain external facts, for example, the spending patterns of a particular criminal, we can look to the blockchain to see whether such spending patterns match those of a particular public-private key pair on the blockchain, or a series of such pairs. And what this does is that we are able to eventually verify the identity and the conduct of the criminal through the two pieces of the puzzle. The first piece being the external data, and the second piece being the blockchain itself. So the difference between the two meanings is that in the first meaning, the blockchain can't allow us to draw any inference at all about the identity of the parties in the crime. Whereas the second meaning of blockchain, the second meaning of anonymity is that it's the identity of the party that's not on the face of it apparent from the blockchain, but we can use the blockchain to infer the existence and identity of the parties. So that's the difference between the two meanings, and we can use pieces of a puzzle to explain the difference.
So in other words, for investigators, for asset tracers, for a whole range of people, actually there are opportunities as well as problems that this throws up. Moving just to the final slide, really, really quickly here, a few closing thoughts. Him mentioned it earlier, this is still fundamentally about people. The vast majority of financial crimes, whatever technology they use, exploit certain forms of social engineering. They exploit our biases and heuristics. So when developing defenses against financial crime issues involving crypto, for heaven's sake, don't forget that fundamentally the biggest weakness normally walks around on two legs. The old computer science, IT desk term, that problem exists between keyboard and chair, remains entirely opposite in this. do think like a criminal, do pay attention, start thinking about how this stuff can be used in the context of your business or your client's business. Don't get blinded by the science. If you know financial crime, if you know how to mitigate risk, you still know how to mitigate in this world. But equally, make sure you ask people who actually know this world so that you can amend your behavior accordingly.
So I've already asked the audience whether they would like to put their questions in the group chat or just unmute yourself. So let's just kick off. Is this akin to making payments online? PayPal payments made by credit card or debit card are payments held on trust for the purchaser, such that if the service purchase doesn't materialize or meet expectations, there is a refund. But if you have a wire transfer of money there, then there is no protection? ?
This does rather come back to the question of whether a particular asset is being treated like currency, whether it's being treated like property, whether there's any kind of trust or fiduciary obligation that arises from it.
And also, I think it depends on the blockchain itself. So what's the protocol of the blockchain? Does it allow for reversible transactions? Who has access to the blockchain? So both from the legal and the technical side, this throws up very, very interesting issues, because on the legal side, we can deal with the contractual agreement and talk about whether there's any fiduciary duty, whether there's any obligation on the part of the blockchain operator to rectify transactions. But there's also the question of whether the blockchain itself allows the operator to do this in the first place. So there's both the legal and the technical dimensions to this, I think.
And I realise we haven't touched on reversibility at all today, but that's a question for another day.
You see, another bit of regulation, of course, is nearly all jurisdictions have regulation of e-payments. But nobody has yet tried, as far as I'm aware, to use e-payment legislation for protection in crypto asset transfers. So, it's an interesting analogy. It would be interesting to see some attempts to use that regulatory scheme in the context of virtual assets, but it's hard to know at this stage.
And just my observation is that it just depends on facts and, in what context is the wire transfer taking place? Because there are circumstances in which trust could arise in circumstances where it wasn't received in good faith, or they have noticed that the payor may not have a requisite title.
I think that was an excellent question. Thank you to our panelists. I think we will just wrap it up for now. I know there are probably other questions from the audience, but feel free to contact any one of the panelists on any aspect of the presentation today. And Jeremy, as he said, we will be sharing the slides and further information and resources, which I hope you will find helpful. But I think today we've had a really fascinating debate about human nature, the legal nature of these new assets, perhaps not so new, perhaps they are, old wine in new bottles, as cliches go. But I think it's certainly a testament today to the fantastic collaboration that practitioners can have with those of us who are in academic research, looking at these issues that sit at the interface of law and technology. So thank you very much, everyone, for your participation. And thank you once again to our speakers. Thank you.
Thank you, Mimi. Thank you, everyone. Bye-bye.
That was fun.
Bye.
Thank you very much.